Council, you each have 20 minutes, and there should be a clock. There it is. Okay, I gotta make that smaller. So you each have 20 minutes to make your argument, and the appellant can certainly reserve time. I would just ask that you keep track of it yourself. Also, we are recording this, so when you begin, if you would both state your name and your who you represent, your client, that would be appreciated. We have conferenced the case. We have read the briefs. Please keep that in mind when you're arguing. And with that, let's begin. Mr. Olson, go ahead.
Your Honor, I'm actually the appellee.
Oh, I'm sorry. You know what? Yeah, I have them. This has an upward, backward. So I'm sorry, Mr. Kelly, begin.
All right. Thank you, Your Honor. May it please the court, Jason Kelly for the defendant appellant, Yuma Funding, Inc. I know that you've read and talked about this coming in, but I want to just highlight a few things for the panel. This appeal is really about whether and to what extent the protection of procedural due process rights and the constitutional protections are going to be enforced. The most basic due process rights is the opportunity to put the claimant to its proof. And in order to have any meaning to that statement, these protections necessarily require 1, a hearing, 2, access to one's own money to be able to mount a defense, and 3, the ability to direct the defense of the case.
Well, let's be a little bit more specific. So what process are you referring to, or what happened without process? You're not raising the appointment order, or maybe you are. Are you contesting that?
We're contesting many things. We're contesting that there first of all needs to be a hearing under Rule 66.
For what? A hearing for what?
There wasn't even an ex parte hearing. We put in the record Exhibits 1, 2, and 3 to our motion to set aside that we filed in November of 13. No one even called the case. There wasn't even an ex parte hearing on the application.
Okay. So your motion is set aside. We're not. You would concede, and I can give you a citation on this very case that you have no remaining argument on the appointment order.
No, I believe is Your Honor talking about the SATO case?
I'm talking about 237 areas. I'll give you a paragraph, cite 22, and it says, quote, "The time to appeal the January 2010 order appointing the receiver has long passed, and we lack subject matter jurisdiction to consider its entry, period," end quote.
We are appealing, Your Honor, the denial of the motion to set aside originally filed in November of 2013.
Okay. Understood.
Okay. I'm sorry, we were talking past. I misunderstood. In that order, while we're here, Your Honor, that paragraph 22 also indicates that we can have that question reviewed. And that was dismissed on a jurisdictional basis. And the Court of Appeals in Division 1 in 2015 said you can review, once there's a final judgment or accounting, the denial of the motion to set aside is ripe for review.
Motion to set aside. Those are the critical words, right?
And
not the appointment order. Right. So keep going. I think we understand that.
We're moving to set aside based on the due process violations.
And so now, okay, so we'll move to the set aside, and then what rule did you move under? What subsection of the former Rule 60? These rules are changing so fast. Which subsection?
It was C, now B4, lack of jurisdiction.
C now.
So
Okay.
it's 60B4.
60. Okay, so keep going.
Okay. So when we move to set aside the order, and well, I'll back up. In September of 2013, we asked for some funds back to be able to hire an attorney. And I would submit to the court that every defendant in every case is entitled to at least some of its own money. And we cited some in the pleadings, even where assets like are frozen from someone like an extraterritorial drug kingpin or a Bernie Madoff. People are entitled to their own money to hire an attorney. And we originally sought some of that back.
The key word, since I'm focusing on their own money, was it their own money? Was it your client's money, or was it a collateral? Was there an ownership interest that your colleague's client had?
The collateral, Your Honor, is there for priority perfection. All the plaintiff had was a breach of contract claim, and the plaintiff was allowed to execute on its breach of contract claim without the defendant ever getting a hearing.
Counsel, you mentioned drug kingpins and others. Are there any civil cases that you could cite to support that proposition, or are they?
We cited to several in the briefing, in the opening brief. I'm looking for the page right now. Starting at page 49 of the brief, we have several cases involving the FTC where it said that defendants are entitled to their own money. So this is the government action coming in, the FTC deciding there's been some wrong for which they file a complaint, and the FTC, the U.S. government, is required to leave some of the money in the defendant's accounts pending the litigation.
But it's not collateral for a debt. I mean, your argument is that collateral doesn't mean a great deal. I guess
Oh well,
it's just sort of you put it up. Oh well, you had it at one time. I'll give you the loan, and that you're not making the loan decision based upon the certainty that it'll be there when you open that door.
Well, 2 points. One, if there's collateral that the defendant really needs, that's called a replevin action. And under those statutes, there's a requirement of a bond that's in a multiplier of the stated value of the assets. In this case, there would have been a $4, $5, $6 million bond to protect against just this instance if there was replevin. So you can go replevin collateral. You cannot, on a breach of contract claim, get a receiver to run the company before the adverse party has a chance to put on a defense.
So on that motion to set aside, is there any time element that we would consider do we account for the fact that your client did or did not file it for days, weeks, years, or is that irrelevant?
It's irrelevant, Your Honor. If the orders are entered in violation of due process, there's no time limit. And I've cited cases in my opening brief on page 34.
But how does those seem very distinct concepts? I mean, if the notion is, I suppose if you're saying we had no idea this was happening, but that's not at least reading the briefs, I don't get the sense that you're saying we didn't know this was happening. You can't just say, you know what, I have a due process argument, but I am busy I'm looking at my calendar here for the next few months. Maybe in a couple of years I'll raise it.
Well, Your Honor, that's not in the record, and it's actually contradicted in the record. But I would point out first, if there's no jurisdiction because there's a violation of due process, this is Rufino versus Lukoski, 245 Arizona 165, paragraph 10. Quote, the court must vacate such a judgment even if the party seeking relief delayed unreasonably. In this case, I would submit there was an unreasonable delay.
What's that citation, counsel? I'm sorry.
245 Arizona 160, paragraph 10.
All right, go ahead.
In this case, first of all, Yuma funding was dismantled in a matter of 7-8 months. So, once it's September, it becomes a moot point anyway. So the time limit on seems to be, to go down this road, the time limit on it would be just as long as it takes the receiver to take all the money out of the company and give it to the plaintiff. So we can't go down that road. The Rufino case says at any time, even if there's unreasonable delay. In this case, we presented affidavits in the record, part of the 2013 motion to set aside, that detailed the principal's attempts to find an attorney and to raise money to find an attorney. And it's not their obligation to go into their pocket. If somebody
Is there a constitutional right to counsel in a civil case?
No, but there's a constitutional right, if you have your own money, to be able to use it.
And again, it doesn't matter if it's a bank that has a collateral interest in that money. Like, I understand the FTC, I was an antitrust lawyer, you have, we're freezing millions of dollars in accounts, but it's not tied to some sort of, possessory, it's not tied to a loan.
There was no possessory interest. There was a lien interest, a security priority interest. To exercise the possessory interest, you need to go through the replevin statutes and post a multi-million-dollar bond so that if you're mistaken, when there's a hearing, there's a bond protecting the defendant's assets.
So why didn't you raise that argument when they were moving for the appointment of a receiver and wait, or why did you wait 3 years or how many years to jump in?
Well, that's when I was contacted. And again, we have the affidavits in the record as to what the other side tried to do. I would also point out to the court that there were injunctions in the order stopping anyone interested in Yuma funding from interfering with the quote-unquote receiver's control of the activities of Yuma funding, which included hiring and firing counsel. When the receiver was asked this question, and we cited this in the reply brief, when the receiver was asked the question, you were appointed, you were given the power, why didn't you do anything? He said, well, I just figured I wasn't appointed lightheartedly, but yeah, it's a catch-22 for Yuma funding.
Okay, so you're arguing Rufino, is that what you said?
Well, Rufino on timing.
Okay, I was on that panel, and I don't think it had anything to do with trust receivers or let me see, that had to do with it was, I think, a defamation. I don't remember as well, but just you're saying on timing in the context of Rufino. Okay, well, go ahead.
Rufino's not cited because it's a receivership or an injunction case. It's cited for the timing on vacating judgments entered without due process.
Well, but we're talking, it was a service issue, again, your client knew this was going on.
And it was enjoined from acting, both by order of the Superior Court and by the practical reality of not having any money left and not having a way to make money.
Where's the order enjoining your client from making an appearance and defending?
The order at page 3, paragraph 3C, Yuma Funding and any persons under Yuma Funding's directions are enjoined in any way from disturbing possession of the property, prohibited and restrained from disposing of, dissipating, mishandling the collateral, prohibited from taking actions that would have an adverse impact, prohibited and
So
restrained.
you're saying that meant they couldn't.
Prohibited and restrained from collecting payments. On page 4, paragraph 3E, Yuma Funding shall not impede, obstruct, hinder, enjoin, or otherwise delay with the exercise of the receiver of any steps taken by the receiver to operate or manage Yuma Funding.
So your argument is that by appearing in that case and contesting that order, which was certainly, as receivership orders almost always are, entered rapidly, that you would have been in violation of those provisions you just read.
Nobody has raised the issue before then, but before now. But I mean, that, of course, that begs the question: is anyone ever permitted to object to it? Then, if I'm in contempt for filing that motion, then no one should have been permitted to file the motion, which proves it's unconstitutional.
I don't read that order as prohibiting anyone from pursuing legal methods, specifically from appearing in court. And I would be surprised if your client would testify that the reason they didn't appear for 2 years or 3 years was because of that order. But if you want to keep making that argument, you can use your time. I would suggest you move on.
All right, I will. So the question still becomes whether a hearing should have been ordered and who's the obligation. Rule 66A sets forth that there needs to be a hearing, and that's what we're talking about. No chance to put anyone to the proof. I think the language of the order is very clear. I do want to touch on the damages hearing that was eventually entered, because the person who came, Mr. Darren Davidson, who came to lay foundation for the damages evidence, testified he didn't know anything about these files except the original amount of the loan. Maria Malta, who used to work for AEA, said none of these spreadsheets introduced are verifiable because we don't have any of the backup documentation. I would submit that Ms. Malta's common sense approach to this is mirrored in our rules of evidence, that it doesn't matter how many pieces of spreadsheet paper you submit, you need to have the backup documentation made available. Otherwise, there's no admissible evidence proving any damages. So I don't want to lose sight of the fact that even with all these constitutional issues we've raised, there was no evidentiary basis for any award of damages to Yuma Funding. For that reason alone, the final judgment should be set aside. And we're back in the position of the trial court needing to take admissible, competent evidence. We get back to square one. My client would still like some access to its own money in order to present economists, accountants, and or maybe even a computer forensic expert to go through and get these documents. We know all this evidence existed in December of 2013. Ms. Villalobos said it did. There was no reason to destroy the evidence. I was on the scene by that time. And Yuma Funding still failed to come forward with any admissible evidence at the hearing. And for that reason, the damages should be zero, and we should be entitled to a return of some funds to properly litigate the case with actual backup documentation about what was collected or not collected. I'd reserve the rest of my time unless the panel has any more questions.
No, thank you. Thank you very much, counsel. Let's now go to AEA Federal Credit, and Mr. Olson, go ahead.
Good morning. Before I get into some of my brief argument, are there any questions that the panel would like to ask of me to address from review of our brief?
I have none, but that doesn't mean I won't have questions.
Okay. Basically, there's two well, first of all, I'd like to start off in listening to my colleague's argument. This is nothing more than a redo of what I call Yuma funding number 1, which was before the Court of Appeals 5-6 years ago. And the court is obviously readily aware of that decision. So what we're really here for is following the judgment after a hearing on damages after the entry of Yuma Funding's default. I didn't hear anything from my colleague relative to the default. There's no disputed issue of law or fact that the default of Yuma Funding was properly entered. Yuma Funding moved to set aside that default, was unsuccessful. What I see Yuma Funding...
What about the notion that collateral is sort of not aspirational, but your client has any sort of possessory interest in that?
Well, that was early on in the case, we had a hearing on that before Judge Plant, and there was a specific argument relative to the collateral. AEA had testimony, provided the UCC financing statement showing that it had a cash collateral interest, and pretty much the judge had no problem determining that AEA was properly perfected in the collateral that was awarded to AEA.
And when was that? Just so I have it in front of me, I have the record. What month and year was that?
Oh, well, this case has a prolonged history.
That's fine. Go ahead. I'll find it.
I would say it was in mid-2000 and probably 12 or 13, shortly after Mr. Kelly got into the picture.
Okay.
But back to where we're at. We cited the case law in our reply brief as to what's necessary at a damages hearing following the entry of a default. It's not a full-blown evidentiary hearing. In spite of that, Judge Plant held a 4-day hearing where volumes of accountings, loan files, summaries were all presented to the court. And as you can see from Judge Plant's order, he went through that somewhat meticulously and ordered AEA to basically recalculate its accounting as to damages, which in fact favored Yuma Funding. And that is the basis for the entry of the final judgment against Yuma Funding, if any, conservative in favor of Yuma Funding.
Mr. Olson, if you could, I just want to make sure I'm tracking everything here. Your colleague argued, and I think reasonably, that our last decision from this court on this case specifically said that Yuma Funding's challenge to the appointment of the receiver, or motion to set aside the appointment of the receiver, could be heard on appeal, correct? So yeah, we have that case before us, and that's what they're arguing, is that the denial of that motion was inappropriate, or was error.
Well, as to that argument, again, this goes back to the first argument. First, we've always claimed, and still do, that any objection to the appointment of a receiver is time barred. They had 30 days to file an appeal. They didn't do so, and that was the basis for the decision in Yuma Funding number 1.
Right. But they then filed a Rule 60B motion to set aside the order releasing the receiver.
Correct. But
and that motion was denied, and I think they filed that in 2013. And our last panel decision said they could take that up on appeal when there's a final judgment, correct?
Yes.
Okay, so let's talk about the merits of that motion and whether or not it was correctly denied.
Well, we contend it was correctly denied for the reason that this, and a lot of it is overlap with the Yuma Funding number 1, but the court heard all of the argument, all of the testimony. But again, you have to also keep in mind, and as was pointed out by the panel, receivers are appointed in quick order. The receiver in this case, within a matter of 7 to 8 months, had basically performed all of his duties, Then through hearings before the court with no objection, the receiver essentially was released. During his appointment, he filed, I believe, 6 to 7 different reports specifying his actions, what he had done, provided accountings as to what had been collected. And then in the middle of, I believe, 2010, the Superior Court, after hearing, reviewing the receiver's final report, essentially discharged the receiver and ordered.
Right. And counsel, we understand that, but let's focus on Rule 60 and what the requirements are to set aside, and we have it's a menu of options, and why, again, not so much looking at the appointment order, but why that under the prima facie elements of Rule 60 that was or was not correct. So my first question, is there a timeliness? Does it matter whether they waited 3 years, or is that immaterial under Rule 60?
Well, I believe it's definitely material under Rule 60 because you've got a latches and a waiver issue. Is Yuma Funding sat by knowing exactly what the receiver was doing?
Right. Is it in the rule?
Well, as I recall,
Some common law theory.
Well, I think inherent in the rule is that anytime you're filing a motion to set aside an order or a judgment, that it be filed in a reasonably timely manner. And I know there are some instances where you have to file within a specified period of time. I think it's 6 months. And whether this falls under that or falls under the general rule that you can file at any time, you still have to look.
Counsel, what it says is it must be filed within a reasonable time. Explain to me why this wasn't reasonable or was reasonable. And just to give you, it's Rule 60C1. But go ahead, using reasonable as the standard.
Well, we contend it wasn't reasonable because Yuma Funding did nothing in this case until almost 3 years after the entry of the January 2010 order. By that time, the receiver had fully performed his duties, had been discharged almost 2.5 years prior to that. All of these, what these collateral consisted of for the most part, besides the cash, were performing automobile loans. And those loans were turned over by the receiver to AEA, which as a credit union is in the business of, administering car loans, administered those loans, accounted for those loans, and there were quite a number of those loans by the time Yuma Funding even appeared in this action had either been paid off or had been repossessed or were still performing. It depended on, there's 250 plus of those loans. So for Yuma Funding to come in 3 years after the fact is not reasonable in any manner that I can think of.
Well, they said they didn't have money to mount a defense.
Well, again, as the panel has correctly pointed out, there is no right in a civil case to a defense, unlike in a criminal case. It's basically...
But you have a right to your own money.
Well, if it is their money, and it's our contention, it wasn't their money, it was collateral of AEA that the court determined was appropriately provided by the to the receivership, who in fact on the final order in July of 2010 turned it over to AEA in accordance with the court's order.
Was that the basis for the court's denial of the motion to set aside timeliness?
I remember the court kind of summed it up best when it said, you simply waited too long. It was something, I'm paraphrasing, but that was what Judge Plant, after hearing the same argument from my colleague, basically determined is too much has happened. It would be unjust and unreasonable to set everything that aside that had happened up until that point in the case.
But you don't know? I mean, you can tell us with certainty? That was his decision. What if he decided on some other basis?
That's paraphrasing what he was, but basically he determined that they had waited too long and that the delay was unreasonable.
Is there any prejudice requirement under Rule 60? Are we supposed to consider that, meaning whether or not your colleague's client suffered prejudice by not, what difference would it have made had it been set aside? What good arguments might they have had that they were, they had ready in their back pocket, they just didn't have the opportunity to deploy?
I don't know what arguments they would have had. There was never any evidence that they were not in default. The only argument is they have this circuitous argument that based upon some testimony that they were a positive cash business, and obviously we never got into the liability because at the damages hearing, liability was not an issue, it was only the damages. But if you look at the face of the complaint upon which, and the application to appoint a receiver, it clearly set forth that Yuma Funding was a material default of the various loans that it had with Yuma, with AEA.
Now, the trial court did have some serious problems with your client's damage presentation initially. Isn't that right?
Correct.
Okay. And what can you explain what those might have been, and then how you addressed them?
Well, there are a couple of points on that. You're dealing with 250 plus automobile loans, but what happened, a couple of compounding things happened in this. One is by the time we got to the damages hearing, it was approximately 8 years after the lawsuit had been initiated. So AEA has, like any other business, a significant turnover in personnel. So by the time we got to a hearing, there essentially was nobody left at AEA who had been involved in the servicing of the Yuma Funding loans. Then, as cited in the brief, in late 2009, early 2010, AEA was basically put into receivership by the NCUA. So that resulted in additional staff turnover. So, but during this period of time, the loans were accounted for and administered by AEA. And so then to compound matters even further is the original accounting system, well, there's 3 accounting systems. When the loans were at Yuma Funding, it had an accounting system that was essentially archaic. It was on the folders, and it was using an accounting system that's prohibited under standard lending practices. Then when the loans were turned over to AEA, there was another accounting system that the business lending department was using, this LA Pro system. And then there was a third accounting system, which was called Galaxy, that came into effect. So by the time we got to trial, AEA had to reconcile what had occurred with the loans as they started at Yuma Funding, how they were tracked on the LA Pro system at AEA, and essentially how they were converted to the Galaxy system when they were put into the system upon being turned over by the receiver.
And how did that? How was that? Is that hearsay evidence? How did that get in the record?
It was testified to by Darren Davidson, testified as to what AEA had done in the history of those loan files. There were a couple other.
No, I understand. There was a witness that laid some foundation, but how does it come in? What exception to the hearsay rule? I assume the documents came in. Did they not?
Yeah, they were all admitted under the business. They were admitted as business records.
Okay, so I think that's an issue that your colleague raises, is whether or not those should have been admitted or not admitted. Do you have anything to say about that?
Yeah, well, what he's arguing about is, their argument is basically that AEA should have produced, and they were produced in disclosure in this case, is every receipt that had, from the beginning of these loans, the receipts and copies of all the checks for the payments. And that's just, I mean, you're talking thousands and thousands of pages of checks, receipts. Most of this have been check or debits from accounts. But again, the summaries that were before the court, and Judge Plant didn't have any problem with this because he made a determination, because we had prior hearings on what AEA would have to produce, and it produced the accounting records that showed by date when payments were made and applied towards the various accounts. And the court determined that was reliable evidence in going through its accounting and the mechanism that the court came up with and instructed AEA upon.
And so what rule did those summaries come in on?
I think we quoted in our brief. I know it was in the Series 1000, but but that's what the judge essentially determined, is he didn't have any problem with the summaries. And again, there were volumes of evidentiary. I think it took up a full cart of evidence that was in the courtroom at all times, to which Yuma Funding also had access to.
Okay. Do you have anything else, Mr. Olson?
I do not.
Okay. Well, thank you, counsel. And let's go back now to Mr. Kelly with Yuma Funding.
Thank you. I'll touch on this last point first. And I put it in the pleadings. I put it near the front of the factual section. Darren Davidson testified he had no idea what any of these numbers were, who entered them, except for the original. The only thing he verified was the original loan amount. So recall, the money was loaned from AEA to Yuma Funding at about 7%, and then Yuma Funding loaned it out at 18 to 24%. So AEA is only entitled to its 7%. No evidence whatsoever was entered as to what got paid, when, and by whom. And this is important for many, many reasons, but not the least of which is AEA started servicing loans. We had Darren Davidson testify that even during the receivership, AEA was repossessing cars and taking payments on loans. So the spread in between the 7 and the 18 is vitally important to any surplus to be returned, yet it was never admitted. Davidson said, all I know is the original amount of the loan note. When we brought up Maria Malta, she said, I cannot verify anything. AEA could have bought in 43 carts of computer printouts. They're all meaningless without the backup documentation. It was never made available. It was never entered into evidence. It's nowhere in the record. And this is
Kelly,
important.
can you cite me to a case? Because my understanding is that business records are routinely admitted without necessarily all the documents that might have gone into creating those records. And if these were admitted as business records, why do we have to see the underlying loan data or loan documents to support it?
I conflated the two a bit, Your Honor. If you look at the 803 exception for business records, there are 5 or 6 requirements. Mr. Davidson couldn't testify to any of them. I conflated
Which are the ones
that.
that he didn't testify to?
That's all he testified to. Here are these printouts. I don't know who entered the numbers, but I got them off the computer. That's not business records.
That they were regularly kept in the normal operations of the business.
When I voir dired him on that issue, he could not confirm any of the underlying requirements to that hearsay exception.
Okay.
And so I conflated 1006 with the 803 exception, Your Honor, and I apologize. But 1006 does require, if you're going to put these summaries into evidence, that they need the backups need to be made available. They were never made available. They were never produced. They're nowhere. We don't know what these numbers mean. And it is important. In 2013, when I was involved, Ms. Villalobos testified, I cited this transcript testimony as well, that she had access to all this. Whatever turnover may or may not have been going on at AEA, they were in the middle of an actively litigated lawsuit. And their former employees said they used to have these records. So you can say all you want, we had turnover. I don't think that absolves the burden of coming forth with admissible evidence and preserving crucially important evidence.
Okay, well, thank you very much, both of you, for putting up with this strange process of video argument. We really appreciate you working with us. We will, and thank you for your arguments, and we will take it under advisement, have a decision in due course, and with that, we are adjourned.
Thank you both.